Looks like the Marthas are ready. We'll start with Martha Lucey.
Thank you, Your Honor. May it please the court. I am Martha Lucey, and I am here representing T.J.W, who I will call T.W. It's a lot easier, or W. In Patterson, this court reserved or declined to answer the question of whether it is proper to enter a restitution order in a dismissed case and save the question for another day. Well, that day is today. T.J.W. would ask that this court find that there is no subject matter jurisdiction to enter a restitution order in a dismissed case. This case arrives here in sort of an unusual way. T.W. was given a deferred judgment in August of 21. There was a review hearing scheduled for February of 22. That hearing was held. There's no record of it. There was not a court reporter. And the district court found that she had completed all conditions of her deferred judgment, entered an order dismissing the case and expunging it. The order then further said expungement would not happen until all monies owed were paid in full.
Is that a form order? Is that in every order?
I don't know. I really don't.
Cases here, I know the co-defendant as well, and I'm just thinking that the language, I'm just wondering if it's standard.
If I were to guess, which I'm sure you don't necessarily want me to guess, I would say it probably is. I think that there's a possibility of mixing some language from the expungement in 901C with expungement in 907. 907.9 does say that a deferred judgment will not be expunged until all monies are paid. But it also, 907.9, provides that if monies are owing still, the case still can be dismissed as long as there is a payment plan entered prior to dismissal. So in this case, what we have from the district court is that T.W. had paid all monies owing because that was a condition of her deferred judgment. All money that had been entered prior to dismissal. That would have included the civil penalty and a $100 in Category B restitution.
To me, this looks like a coincidence that the same day the deferred judgment is entered, another judge sends out this order setting a restitution hearing. Is it like maybe the right arm suddenly started talking to the left arm, or do you know what happened there?
I do not know, and my answer to a lot of things will be I do not know. And that seems to be my answer a lot lately. I actually have a T-shirt order that says I do not know. What happened initially when the deferred was granted, there was a restitution hearing scheduled for some time, and I think it was in October. That didn't happen. The record doesn't say why. It doesn't even have an order saying it didn't happen, we're now going to schedule it for December. I believe the December order, I believe there's another order that says, okay, it's now set for December. No further order at that point. February, the district court says she's completed all conditions. Case dismissed. I don't, is it true that all money had been paid? I mean, from this record, I can't tell, but the district court said so. And if the money had not been paid, then there should have been a payment plan entered prior to dismissal, which the docket doesn't show. And again, I will admit up front, I do not know whether the Scott County attorney.
Do you ever pick up the phone and call the defense lawyer from the trial level and ask for any of this information, what's going on?
But it's not in the record, so I shouldn't be telling you anyway.
Understand a little bit more what's going on in the case.
Mansfield, but one of the difficulties is that once you know that information, then it can creep into the case where it's not part of the record.
Agree with that. I mean, I used to handle criminal appeals, and I talked to the lawyer who handled the case below. I don't quite get that.
It's not in this record, so it's not something that the court consider, even if it was, I mean, even if I did know that answer. But there's two ways of a payment plan under 907.9, which is with the clerk of court, which we do not have a record of. It's not filed, or with the county attorney. Does the Scott County attorney do payment plans that are not filed in the case? Again, this record does not show that. But once the case is dismissed, there is no longer subject matter jurisdiction to enter subsequent orders.
Counsel, do the changes that the General Assembly made a few years ago to restitution affect this, where they recognized or required that there be a permanent restitution order entered at the time of sentencing, and then provided for that permanent restitution order to be modified later?
Done within the life of the case, victim restitution could have been entered after sentencing. Because 910.7 says you can modify, the judge can modify upon motion of the defendant, county attorney, or the person who developed the plan of payment, or whatever the other part of the plan of payment is. That can happen during the time of probation, incarceration, or parole. Subsection 2 says the judge can modify any time prior to expiration. So once you're off of parole, incarceration, or probation, the case is over. So therefore, the judge cannot modify past the time of the completion of the case or a dismissal in this case.
Hold, is that going to create any problems, or is that an easy rule to follow? Just get your restitution scheduled before the deferred is completed.
Has the obligation to seek the restitution. The defendant doesn't have the obligation to do that. The district court only has the obligation upon request. So it's not going to create problems. I think that this is probably an unusual case maybe, but then again, I don't know if it really is, because we're back here talking about judgments entered in dismissed cases.
Right, but that other case is a little different, wasn't it? As I understand, it was a deal where there was a count dismissed, but then the understanding was that there was allegedly an agreement the defendant was going to pay restitution anyway. I don't see evidence of an agreement here.
Evidence, I mean, I think that the agreement would be is if restitution is proven and ordered, then she would be required to do that, but that's not an agreement.
I mean, it seems to me there's some logic behind what you're saying. I am concerned, though, that the person that ends up, bearing the consequences is not the state, but the victim.
And the state, as we know and we've heard in many, many cases, the prosecutor does not represent the victim. The prosecutor represents the state of Iowa. I
Pursue the restitution on behalf of the victim, right?
I think under their rules of professional responsibility, I think that would be within their duty if they believe that should happen. The victim in this case, and I'm going to call her a victim because my client pled guilty and got a deferred judgment. She also has a civil right to seek damages if it's within the statute of limitations. I understand your concern about the emotional appeal of, well, what about this woman? But we're at illegal.
I would guess it's going to be very hard to collect from your client, other than if it is through the criminal justice system. And I mean, you would agree the video shows that your client did participate in bashing two of her cars in, right?
Video shows that she broke or cracked the windshield in the Ford. I would agree that the video shows that she damaged the windshield, co-defendant damaged the hood, and the sunroof. I definitely agree with all that. I disagree that the video shows that she did any further damage to the Ford. I think this case can end at subject matter jurisdiction. When a case is dismissed, it's over. It can't be resurrected. The state has an alternative theory that it was an illegal sentence and therefore the case could be reopened. I disagree with that. Principles of finality, statutory authority, and issues of double jeopardy preclude reopening this case.
Should have the state done here? Because the state's argument is we submitted what we needed to. The court set a hearing, continued it, but we did everything that we could do. That's sort of the state's argument here. Why are they wrong about that?
After the hearing didn't happen, they should have filed another motion asking for a hearing. They should have shown up at the review of the deferred judgment and said, but wait, we have more.
Question about that. On that hearing, you just talked about the review of the deferred judgment. Is that an automatic thing built into the date that the deferred judgment's granted?
It's scheduled at the date the deferred judgment was granted. I believe it was for the Friday, which I think should have been February 18th. The order actually was entered on February the 15th. The order shows that defense counsel was there, my client was not, and the state was represented by a county attorney. I don't remember if it has a name or not. Maybe just says prosecutor. Again, forewarner, I don't know, but we go by what the judge says. Unless we have something contrary, that's the order that says that the state was present. So yes, the state has the duty to seek and prove restitution. They have to keep asking for a hearing. With what little time I have left, I'm going to pivot and talk about the substantial evidence. We have the video from the date that CB took the video, and it does show the two young women causing damage to her two vehicles. The district court finding that BD and T.J.W walked away at the same time is clearly not supported by the video. We also have photographs that were taken by the CSI officer that show the damage to the two vehicles. The Hyundai certainly had damage prior to this incident. There is significant front-end damage by the right side headlight. Part of the headlight's actually missing, or turn light probably. CB testified that she had no other damage to that car, and that it was in good shape other than it needed brakes. Clearly there was damage to that front end. Does that put that vehicle in good shape for evaluation? The video and the photographs show no damage to the Ford.
Those two cars took a whooping.
The Hyundai took a whooping.
Windshield on the other one, correct? You take a crowbar or whatever it was that was used, I can't remember the instrumentality, but we don't usually have that kind of evidence showing the actual crime occurring.
Doing that at all. The windshield is broken. The windshield is broken, but the estimate shows that CB wants compensation for all sides of that vehicle when there is no evidence.
You caught 100% of the whooping?
There's portions that are covered by her finger, but there are seconds that my client got around the other side of the car and caused all that damage to the driver's side, which would be the left side, that's not supported. We have an officer who went out and looked at these vehicles and documented what they looked like. We have a CSI officer who went out and took photographs, 22 photographs. And it doesn't show any of that damage to the Ford. And I see that my time is up. Thank you very much.
May it please the court? Martha. Restitution has two purposes. It is designed to rehabilitate an offender by making him or her responsible for her actions, and it's also designed to make a victim whole. If this court finds that the district court was without jurisdiction to enter that restitution order, neither of these purposes is satisfied, and we're left with a defendant who is no longer financially responsible for her own admitted actions, and a victim who is left with two damaged cars, one which had to be totaled.
Taking their anger and frustration on the cars. But didn't the state totally drop the ball? Seems to me like deferred judgment was given, attempts were made to have restitution, and for whatever reasons it didn't happen, and everybody knows there's a hearing coming up, we're going to let go of it. Why didn't the state jump in at that point and either ask for a continuance of that or get their stuff done? But it seems to me like the state dropped the ball.
With that, Your Honor, and I disagree with it for two reasons. First of all, the statute requires that the state provide a statement of pecuniary damages, and we did that. We did it twice. One, I believe, was in June, and the second one was in February of 2021. As far as the state knew, after the deferred judgment was entered, because the amounts were in dispute, a restitution hearing was set in October. Inexplicably, that didn't happen. It's not clear from the record why that didn't happen. It went then to December, where a second restitution hearing was held, or was ordered, but it wasn't held either. Now we fast forward to February, when there is a hearing on the deferred judgment, and again, still no restitution hearing, no order. It is not the responsibility of the state to get to have a restitution order. That responsibility rests solely with the district court. And that's why we assert that the...
With that, I mean, really? I mean, the state is, the state is the one that wants relief from the court. I mean, if you're a prosecutor, you want something from the court, you make sure that you get a hearing to make it happen. Right?
Had happened, we could avoid all of this. But Your Honor, I think that what the takeaway is...
Asked Ms. Lucey, did you talk to the assistant county attorney and try and figure out what happened?
Not, for the last 30 years, I have made that a policy not to speak to the local prosecutor for fear that I would discuss something that is outside the record.
Dropped the ball, and I don't mean you personally, Martha. Okay. In October, okay, for whatever reason, it didn't happen. December, it didn't happen again for whatever reason. I think every trial judge up here knows we have schedules like that where we just have to keep kicking the can down the road. February, that's where I would expect the county attorney to stand up and say, Your Honor, with all due respect, I know we're set here today for review of the deferred judgment. We do not yet have an order for restitution. We can't move forward. Or can you do this first and then follow it up? Isn't that also dropping the ball?
Your Honor, it is perhaps not the best set of facts for the state, but let's look at then what happened after the fact. So 2 hours and 7 minutes after the order entering the deferred judgment or the expungement and dismissal, a restitution hearing is set, and the hearing is scheduled for March. The defendant appears personally and participates in that hearing. Actually, both defendants, the co-defendants, appear. If the court lacked jurisdiction, lacked subject matter jurisdiction, one would think that the defendant would raise it at that time, yet she participated in that. In fact, if you look at the order regarding restitution, the order states that the defendant doesn't dispute restitution is owed, just the amount requested. I would analogize this case to State versus Mendocino, which is cited in the brief, that the defendant complains a bit of a self-inflicted wound. If the district court never ordered restitution, that is a void sentence. The statute requires, under 910.2, that in all cases involving a guilty plea, that the court shall order restitution.
Those statutes then, under 910.3, the court is required to enter a permanent restitution order at the time of sentencing. Okay, and so is that August 19th order, or is that considered a permanent restitution order?
Well, no, it is an order directing that a later hearing would be held. So in that instance, it contemplates a,
In front of me. It says, if the full, under 910.3 sub 9, if the full amount of restitution cannot be determined at the time of sentencing, the court shall issue a permanent restitution order setting forth the amount of restitution identified up to that point. Okay, so as of now, we have a permanent restitution order of basically zero for the pecuniary.
I disagree with that. Well, we have an order for restitution. If you want to term it a permanent order,
It's because, the General Assembly changed this, and we used to have this whole mess about when we can order restitution and when it's permanent. And so the General Assembly fixed it, and they said a permanent restitution order at the time of sentencing in sub 9, is that right?
yes, I believe that is correct.
Process is that permanent restitution order can be superseded by a subsequent order. Okay, so then you go to 910.7, and that's where Ms. Lucey was talking about, under sub 2, the court at any time prior to the expiration of the offender's sentence may modify that plan of restitution. And so does 910.7 sub 2 apply?
It does not apply for the specific reason that this sentence is illegal and that the sentence can be corrected at any time. The sentence is illegal because under 910.2, the court has a mandatory duty to impose restitution. It did
Order of zero until it modified it.
Legal sentence, that's within the legal range for a sentence for this particular offense.
In State versus Jenkins, you said that the court does not have discretion not to enter restitution. Now, it was all the parties knew.
That the procedures for seeking and obtaining restitution and proving it up are met, right? There are lots of cases that do not have victim restitution ordered.
Yes, but there are a lot of cases that didn't, where the state requested it and the district court never entered that order.
Quick to blame the district court for not acting. What if you talked to the assistant county attorney and found out maybe the assistant county attorney didn't show up at one of these two hearings?
Your Honor, I would think that would have been included in a subsequent order. I'm at a loss, as is Ms. Lucey, why there was a hearing. In fact, the state had subpoenaed its witness. But there is no indication in the record as to why those hearings did not occur. And
Late is too late. So
it is too late is the state, let's just assume that the restitution hearing hadn't been ordered. The state would still have the ability to seek certiorari and allege that the sentence was illegal because the court expunged and dismissed a case without having ordered that. So I think that when you look at the cases regarding illegal,
never too late.
I think that depending on the facts and circumstances of the case, specifically, if the state had never asked for restitution in the first place, I would be hard pressed to argue that, it's never too late. But I think at this point, when you have this kind of perfect storm of factors where we have restitution that has been requested, no hearings, the statement or the case has been expunged, and then we have this realization that no restitution had been entered.
Is the state's theory that this is an illegal sentence. Our case law is pretty clear that can be corrected at any time.
Yes, I agree, and that's why I raised it.
That parties cannot agree to an illegal sentence, and that's expressly or intentionally or unintentionally. So it seems to me, if you're right, that this is an illegal sentence, then the state can just crack open any dismissed case at any point in time and just seek restitution. And why is that not true, given our illegal sentence law?
I think that when you look at, so we look at probation revocation, and I think it's the Jensen case. When you look at the state or the cases that were cited by the defense in reply, and we look at, okay, is this a violation of double jeopardy? Is it a violation of due process? At some point, and there was a State versus Houston, it's a Court of Appeals case regarding the state's later attempt to add a special sentence after the defendant has already served his sentence. I think that you can read that it may not have a limitation. If you look at State versus Allen and State versus Draper, all of those were illegal sentences that were corrected during a particular time while this defendant was serving the sentence. We don't have that situation. So this is kind of left open by what had been argued in Allen.
That Justice Oxley quoted, doesn't that say that if the defendant wants to do anything about the restitution, they have to do it during the period of the sentence, while the sentence is ongoing, or the probation or parole, some language like that. So you're saying that the state could actually come in and get restitution when it's too late for the defendant to raise an objection to it under the statute, right?
That in particular, what I'm saying is at least we should have had 30 days to allege that the courts should not have dismissed and expunged that record. We could have sought an appeal. The state's entitled to just as much fairness as the defense.
At the hearing, weren't they, where the deferred judgment was, so, and the state was on notice that the restitution hadn't been awarded yet. They were also litigating that.
Later, the order setting the restitution hearing is set. A 2-hour delay in that particular time. If you look at the cases regarding whether or not you can, when it's too late to correct an illegal sentence, those cases stand for the proposition that the Constitution, as far as double jeopardy, is not meant to be, oh, there's some error here, and then the defendant gets off without any explanation. If the court, if as the defendant alleges that the court lacks subject matter jurisdiction, which we dispute, clearly the defendant, your cases, Mendocino and Pella Roll Screen, all provide that they may have, the court may still have authority. And that's what we submit, that the court did have authority to enter that.
Agree with you, it's not a subject matter jurisdiction issue, but it is an authority issue, and the authority comes from the statute. And the statute is very clear that says that they can modify the restitution order up until the time the sentence is done. And so once it's dismissed, where's the authority to come back?
To read the statutes in pari materia. You're going to have to read 910.2 in conjunction with 910.7. And if the court never entered that order, and again, I don't
Agree with you, but in 19.7, that was where I started out with the permanent restitution order and the requirement in the statute that they enter a permanent restitution order at the time of sentencing. So in August, when they entered the order that said restitution needs to be set, that was a permanent restitution order of 0.
Still, it would be subject to modification. Yes. Yes.
And it's been dismissed, and that's my issue, is that even though the order setting the hearing was 2 hours after the dismissal, there was not an order of restitution entered for a couple of months. Is that right?
April, that's true. Yes.
That it is possible for there to be a contested restitution hearing. State puts on its evidence, says 10 grand, this is the number we want, 10 grand, and defense does a bang up job and they persuade the court, no, there's nothing owing. And a final restitution order really could be 0 even after a hearing.
It could. I would dispute that it would be on this instance because
Well, it is possible to have a court determination that even though the state's asking for restitution, the outcome is going to be zero. Maybe the state did a lousy job putting on its evidence, whatever it may be. My point is a restitution order can be zero.
It is,
It's proven otherwise, which is the point I'm getting at. There was an order in place, and it was subject to modification, but the burden was going to be on the state to have a hearing.
possible. I have never seen it.
The defense lawyer came in and showed that the victim actually didn't own those cars.
Don't understand your question, Your Honor.
Entitled to restitution, right?
You didn't own the, yes, but that didn't happen here either. I mean, I think that,
Possible, it's not impossible.
saying it's impossible, I'm saying that when we have an instance where the defendant admitted that she caused the damage, she appears for the restitution hearing, and she acknowledges that restitution should be paid, I'm asserting that she has waived the authority or has allowed for the court to enter that order, and that the restitution order should be affirmed because the court should never have dismissed or expunged that record absent a valid restitution order. Thank you.
I will start where Ms. Trout left off. If you look at the transcript of the restitution hearing, I don't believe anywhere in there does it acknowledge that she agrees that she owes restitution. I don't think that the defendant ever said, I agree, I owe restitution. I don't think defense counsel said, I agree that she owes restitution. The evidence shown at that hearing would demonstrate if this court, or if the court had subject matter jurisdiction or authority, it's proven that the windshield for the Ford, I think, is pretty much proven by a preponderance of the evidence. But nowhere did anywhere that T.W. agreed that she owed restitution.
Your response to the argument that T.W. needed to raise this issue earlier, and if this is authority can be waived, and that it wasn't addressed at that time.
And if it is an authority question, then the question becomes, is this like an illegal sentence where the court had no authority to enter it? Is it like an illegal sentence? And this is something that this court had in front of it in Mathis that was not decided also, for no fault of the courts. But if it's authority, that's because there's no statutory authority for it, because it's beyond the time of probation, parole, or incarceration. It's beyond the time of expiration. I still assert that this is subject matter jurisdiction. Once a case is dismissed, the court no longer has jurisdiction. And I would point back to the Smith case from 1906, where the Supreme Court had the issue of whether, after the defendant had completed a sentence, whether the state could correct by nunc-pro-tunc to require that he pay a fine. And the case was complete. It was over. His sentence was served, similar to a dismissal. And the Supreme Court in 1906 said, no, there is no jurisdiction for this. It wasn't about authority. It was about the idea that something has to be final.
There's a deadline that defense counsel has to file a notice once the state has said, we think restitution is X dollars, and if your client doesn't agree to it, is there a period of days or number of days you have to complain?
Law says 30 days, but that's 30 days from when the court actually enters it.
That mark was hit by defense, that they were disputing the amount?
There's never been an order for restitution.
order, but hadn't there been claims, or wasn't there an amount, and then the restitution was to be established later? There has to be somewhere that they dispute it. That's my point. I'm trying to find that in the record.
The hearing, because it was like, we'll set, to be determined later, we'll have a hearing. I believe that that's what the deferred judgment order says. On page 18 of the regular appendix, the order says, a hearing will be set to determine the full amount of restitution to be imposed as a condition of probation. So a hearing was going to be set. The state has the burden of proving by preponderance of the evidence damages before restitution can be ordered. I believe I was here last year complaining about the fact that there's never any notice and opportunity to be heard before an order is entered when the state requests something. So at least here, the state said, we want a hearing. A hearing didn't get set, but nowhere did the court ever enter an amount and make her then say, no, I don't agree with that. Because in a civil case, I'm sorry, Justice Waterman?
Get this straight in my head. If it's subject matter jurisdiction, then that can't be created after the fact. The case is done and over when the deferred the case is dismissed and expunged, and the subsequent participation by the defendant and defense counsel doesn't recreate jurisdiction. But if it's authority, could they waive any objection to lack of authority by participating in the restitution hearing after the case is dismissed?
Participating in the restitution hearing after dismissal is not an agreement or consent. If she hadn't shown up, I think she would be faulted for that. I think I totally lost my train of thought again, too. So my time is counting up. Unless there are further questions, I would add.
Confused by that. It's growing. Yeah.
Be confused by it often.
Or something.
I would ask that this court find that there is no subject matter jurisdiction, that this order is void, and remand for vacation of this order. Thank you.
The case of State versus T.J.W. is hereby submitted, and the court is in adjournment for the afternoon.